Well, it has been 5 years since I made a video here on this channel. I've made some videos on my mechanics channel, but not here. It's been busy. I had the baby, never could get back into a routine, just stayed swamped and swamped and swamped. And now I have another baby that was born in February. I posted some stuff on TikTok. I've deleted that app for personal reasons, not related to China, but related to their policies on, well, they said I violated community standards, but they didn't tell me what I did. And I made some YouTube videos on my other channel for my mechanic stuff, but here I am. I had a trial yesterday. It was my first week back from paternity leave, and I had a trial yesterday in civil and criminal court, and I wanted to kind of tell you about that case. My client was dating a woman. They bought a house together, never married, fortunately, and she got mad at him and went crazy and accused him of jumping on her, punching her in the face, and then kneeing her in the side. Then later called him numerous times, left him a voicemail, said if you give me some stuff, I'll drop the charges. He did what she asked, talked to her on the phone, called her back a few times because they were having a conversation, and then after he gave her everything she wanted, she charged him with violating that order. So long story short, we got everything on one day yesterday and started the trial. And as you would know it, she testified, couldn't remember anything, of course. You can't remember things that didn't happen. So when I asked her, was she wet? She didn't know what I was talking about, but she just testified that my client jumped out the shower and ran and jumped on her and started beating her up. So I asked her if she dried herself off with a towel. I asked her, I said, certainly you had some marks, right? It was painful. And she said, oh yeah, like I said before, the bridge of my nose was red and puffy. I said, oh, okay. So when the officer that arrived wrote in her report there were no visible marks on you, she was lying? So she said, yeah, she was lying. Then she had to go and take these charges out herself because the officer didn't charge because she didn't see any marks. And then my guy returned back to the home and was there, and then came back the following Sunday when somebody called 911. They came out and arrested him. So we had the trial caller stuff out on that stuff. At the end of the day, you know, he's looking at a class A1 misdemeanor, which assaulting a female, being in a relationship that would have pretty much ended his ability to ever own a firearm. Would have been disqualified from work. He lost his job just because of these charges. So we go have the trial. The judge at the end signals that she's a liar by saying, I find that both witnesses, hold on, let me answer. Sorry about that. My wife called 2 times to tell me she didn't have service. And so we had the trial. The assault on the female would have given him, you know, like I said, disqualified him from owning firearms. Certain jobs, he lost his job because of this. Did get another job back, and fortunately had some family to help him out. But the judge says at the end, I find both parties credible, so therefore not guilty on the assault on the female. Now, mind you, how can you find that her testimony is credible, but his testimony is credible too, but they contradict one another? So that was a signal, basically, you know, that she lied. Because if she was telling the truth, then obviously there would have been a guilty verdict. One more time, sorry about that. I'm not a big editor, so I'm just leaving this all in there. It's just me driving after a workout in a long week, so I just felt compelled to put this out here. So anyways, I just wanted to jump in and tell you about some of the things comments made about closing before I get to what the ultimate outcome was of the other charge. In my closing argument, I pointed out to the judge that you'd think that if there was such bruising and such heinous traumatic injury to her body, face and ribs, that she would have had some pictures, and she said that she didn't take any pictures. And you think that such a traumatic injury would have been something the officer would have wrote, or, you know, there'd have been someone here to testify on that. And there just wasn't. And in fact, the report stated the opposite, that there was no visible marks on her body. And then the kicker on that one was her son. Her testimony was her 18-year-old son was there in the home and came into the room and sort of could have overheard and witnessed and was confronted by my client. and he wasn't there. And I called that out. I said, he's not there. He's not here. He could have been here. And so she's like, I didn't know I was supposed to. Anyway, so I'm pointed that out to the judge, and the judge found him not guilty on that. So to the violation of the court order, that was regarding the release order. When he was released from jail for the assault and the female charge, they gave him an order that said basically, do not contact her. So most people don't know this. That's a no contact order for him on her. There's nothing that is stopping her from contacting him. She contacts him, and he said he can't go. There's no recourse. She's not violating any order. She's not being prohibited not to talk to him or contact him. And we had other evidence where she had reached out to him and his family as well. She was there trying to bond him out when he got arrested. But anyways, fast forward 2 months, she swears out a warrant that says that he contacted her over 109 times and her sister through social media and phone calls. Her testimony was he called her 60 times a day from an unknown number. Then he also would text her, and he would just she'd answer the phone from him sometimes, and it would just say, speak, speak. But yeah, we had screenshots of her leaving the voicemail, and I didn't have the audio of the voicemail, but I had a screenshot of the voicemail. But essentially what the voicemail said was, hey, give me the washer dryer, I'll drop these charges. She called several more times, and finally he answered. They had conversations, 20-minute long conversations, 7-minute long conversations. One time he called her back, and so the judge found that he did violate the court order, and we were forthcoming, and I put that case together with the other one so that the evidence would come in that she was a liar. Because I got her to admit that she, in fact, didn't even call him through those time periods. When I showed her the call logs and the screenshots, her memory came clean, and she, oh yeah, maybe one. Then I said, well, how about this one? Maybe two. You know, so eventually she fully remembered maybe calling him more than a couple of times because they were talking about exchanging stuff. Well, anyways, the judge said, well, you know, he did contact her, and despite her contacting her first, he did contact her back. And so what he did was he was going to find him guilty. Well, I let him know, the judge know, that, you know, this charge here is punished by contempt. So I'd like to, that way it's not a conviction, it's just a contempt issue. And so I said, well, how about this, Judge? Why don't you find him in civil contempt and let him purge himself by just not contacting her anymore? And a purge is something that is a technical word for when you are in contempt of court. And you can undo the contempt or fix the contempt by purging yourself. And so if you owe money in child support, you can purge yourself of your contempt by paying some money. So that's what I suggested. But the judge says, well, I'm going to hold him in criminal contempt, but I'm going to continue it for a year. If there's no contact with her in a year, then the case is gone. So essentially, he did find a technical violation of the order, but as long as there's no further contact with him versus her, then the case is over. So I would consider that a win. And I think that it's very important to have representation on your behalf that fights for you, that goes the extra mile. So that case took from August of last year to now, because I was reaching out to law enforcement, getting police reports, issuing subpoenas, corresponding with law enforcement, you know, strategically getting a better judge. There's particular judges who sometimes, you know, you think it doesn't matter what you do, you're going to have a guilty verdict for your client. And I advocated for him when I was there, and I told him what I needed. We prepared for court that morning, and he did well, and he walked out of there with probably, if not the best, the second best verdict that he could have gotten. So I think the judge was fair in that one, and I think that the outcome was appropriate, and I don't think he should appeal that one. He may not get a better result on appeal with a jury trial. So I just felt compelled, you know, coming back from paternity leave, haven't been on here in 5 years legally talking, and just want to come and give you that little story. Hope it was entertaining. If you have any questions, comments, just comment down below. I'll check sometimes. Subscribe. But if you need representation in Franklin County, Vance County, Warren County, North Carolina, give us an email at info@ticklelawoffice.com. I have a new associate who works with me, Charlotte, and she handles out-of-county stuff, and I handle most of the stuff in the county. All right, you have a great weekend. Bye.